Thank you very much, Chairman Schumer. And Mr. Chairman, we really appreciate you holding this hearing today. As you know, I'm a strong supporter of reforming our campaign finance system. I believe one important step is to have a functioning FEC, where all 6 seats are filled with commissioners in terms that haven't expired. Regrettably, that hasn't been the case for quite a while. I hope we can begin to change that with today's hearings. Comprehensive campaign finance reform is crucial to our democracy, but at the very least, we need to make sure that the FEC is enforcing the laws that are on the books. Unfortunately, recent Supreme Court decisions have gutted many of those laws, and we have seen the devastating impact on our elections. In the Republican presidential primaries alone last year, super PACs spent over $100 million. More than half of that was for negative TV ads, further poisoning our political process by groups that did not even have a say as to who was paying for all that venom, but billionaires hiding in dark corners with checkbooks open. The Supreme Court laid the groundwork for this broken system in 1976 with Buckley versus Vallejo. That ruling put a restriction on independent campaign spending and saying it violated the First Amendment right to free speech. In effect, it said money and free speech were the same thing. I don't think we can truly fix this broken system until we undo that false premise. That's why I've again introduced a constitutional amendment. We need to overturn Buckley and the subsequent decisions that relied on it. We've also tried to pass more modest reforms, such as Senator Whitehouse's Disclose Act. That bill had 40 co-sponsors, but could not overcome a filibuster last year. Campaign finance reform historically has been a bipartisan issue. I hope it will be again, and in the meantime, the FEC has a vital role to play by diligently enforcing existing laws. And I welcome our nominees and look forward to hearing their testimony today. Thank you, Mr. Chairman. Mr. Goodman, there was an editorial recently in the Washington Post on July 14th that said, and I quote, "Fundamentally, the Republican commissioners seem not to believe in the campaign finance laws that Congress has passed and that they are bound to enforce." And that's the end of the quote. And I would ask, Mr. Chairman, that that editorial be put into the record.
Without objection.
Can we receive your commitment that if confirmed, you will fully enforce all existing campaign finance laws and FEC regulations, even if you have personal opposition to a law or FEC regulation?
Yes, Senator, you can. I undertake this post with the solemnity of knowing that it is a law enforcement post. I would not undertake it with any intent to subterfuge the law that I'm agreeing to enforce.
And are there any existing campaign finance laws that you think should be repealed or not enforced? And if so, which ones and why?
Well, Senator Roberts addressed some questions to Chairman Ravel and to me that gave some examples of some that should be repealed. And those were the ones that were squarely and unequivocally held to be unconstitutional by the Supreme Court in the Citizens United decision. So, for example, you can look in the U.S. Code, and you can look in the Code of Federal Regulations today, 3 years after the Supreme Court ruled in Citizens United, and you can see in 11 CFR section 114.2b an express prohibition against labor unions and corporations from spending money to make independent expenditures. There's a law that says they cannot spend their treasury funds to expressly advocate to the public the election or defeat of any candidate. That regulation, that rule of law, was held unconstitutional in Citizens United. It has historically been the practice of the Commission to eliminate regulations that have been held unconstitutional, even by courts lower than the Supreme Court. So, for example, when the U.S. Court of Appeals for the District of Columbia ruled 3 regulations to be unconstitutional and to exceed the Act in a case brought by Emily's List, the Commission thereafter repealed those 3 regulations. So that would be a case where I would feel prohibited by the ruling of the Supreme Court from enforcing a law that is still on the books.
Yeah, the unfortunate thing about the Citizens United ruling, in my opinion, is that we've now, and the following speech now ruling, is that we've now reached the point with that ruling that corporate treasuries are now in play in terms of campaign finance. And so just to pick one corporation, ExxonMobil has $81 billion in its corporate treasury that now can go into the campaign system. As you know, in the last election, both the president and all the other federal officials spent about $6 billion. So this is a huge amount of money flooding into the system, and I think it corrupts the system. So, you know, we're going to have to deal with that ruling. I have a constitutional amendment to deal with that, but you're also going to have to deal with that as an FEC commissioner. The New York Times recently published an editorial titled "Sabotage at the Election Commission." I'd ask that that editorial, Mr. Chairman, also be included in the record. The editorial opposed efforts to take advantage of a temporary 3-2 Republican majority on the FEC to change the agency's enforcement rules, including how DOJ and the FEC can communicate. What is your opinion of the proposed changes to the FEC enforcement manual to change how DOJ and FEC can communicate? Do you think the Commission should attempt to make substantial changes when there are only 5 commissioners with nominees pending Senate confirmation? And I'd ask you both to answer that.
Senator, I'll have to defer judgment on the substance of the manual because there is a long history. There's a long-standing memorandum of understanding between the FEC and the Department of Justice that I haven't been privy to. I have not read the extant manual, and my knowledge of it is essentially what I've read in the New York Times and other publications. What I would want to be apprised of is the substance of the historical MOU, historical practice within the Commission, and I'd also want to be apprised of some things I've read in the newspaper about whether or not the General Counsel's office in the Federal Election Commission has been keeping the Commission, its client, apprised of communications with the Department of Justice before I came to a definitive substantive position on how that enforcement manual should be changed, if at all.
Thank you.
Thank you, Senator Udall. I have some of the same concerns and views that Mr. Goodman has with respect to this issue. While I have read the articles in the newspaper, I do not know sufficient information relating to the enforcement manual and the rules of the FEC with regard to voting and what is appropriate in this particular matter. So I would hesitate to make a commitment or a judgment at this moment. I would say that at the FPPC, we worked on the case involving a theft of a lot of money from 300 committees in California by the treasurer, and we worked closely with DOJ and with the FBI on that matter because a couple federal candidates were subjects of that fraud and that theft. So it would be important to me to see what the issues are in this case because I've had some experience in this and think that it worked out very well for California.
Thank you both very much, and we look forward to you sorting out this dysfunctional FEC.